Hi there, this is Jonathan Ginsberg, and today I'd like to talk to you about a type of argument that I sometimes make in a Social Security case, and that is the argument for a closed period of disability. And here's what I mean by that, is that normally in a disability case, you're arguing that your client, at least for me as an attorney, I'm arguing that my client is not able to work, and that condition is such that he could not perform even a simple entry-level unskilled job, and that disability, that inability to work, began on a certain date and it's ongoing. But sometimes the evidence suggests that the disability has come to an end, and it may not be because you feel that you're able to work, and maybe you can't work, but sometimes judges look at these cases, and if they don't see evidence in the form of medical records or supporting documentation, it doesn't matter what you say, they're going to find that your disability came to an end at some point. And if either the disability did come to an end because your condition has improved, or the evidence just doesn't support you, then it's something that you should consider, and that is to go for what is called a closed period of disability. In other words, from date 1 to date 2. And again, remember the definition of disability is that your inability to work has got to be for 12 consecutive months, so a closed period must be for at least 12 months. It could be 14 months, 16 months, to 24 months, it could be any length of time, but it's going to have a beginning and have an end. My experience has been that judges tend to like closed period cases because what that means is they're not putting Social Security on the hook for forever. And especially if you're younger and you're looking at 20 or 30 years of being on disability benefits, Social Security is very concerned about, obviously, their finances and their numbers, and so judges are going to be reluctant to put somebody on ongoing. In fact, that's why they do these reviews, where if somebody has a condition that might improve or the person is young, they may look at it in 2 or 3 years. But you can even, again, if it's appropriate, to ask for a closed period. I've seen judges approve cases for closed periods when they would not approve it for ongoing. And simply by giving them that, essentially authorizing that and saying this is what we're asking for, it worked out actually very well for my client and got us something more than what we would have otherwise gotten if we were trying to be a little more greedy about it. And again, it's a balancing act because you don't want to give up ongoing benefits if it's a possibility you can get them. On the other hand, you don't want to be greedy and give up getting something as opposed to nothing. So I had a case actually that I tried today. This is we're in March of 2011. I'm recording this, and I had a case involving a 20-year-old individual, 20-year-old young man, and he was in a very serious auto accident. As a result of this auto accident, he broke a couple of bones in his leg. I think he broke his foot, a fractured pelvis. He had a closed head injury, meaning that he had a bad concussion. He actually also had a burst bladder. The impact of the collision burst his bladder. He had a torn urethra. It was a pretty serious accident. He was actually in the hospital for over a month. He was unconscious for about 2 weeks. It was pretty bad. And after the accident, he took him about 2 or 3 months before he could walk again and kind of get around. And then he actually had a catheter installed for urination, and that was installed for about 9 months, really. So he was not able to use the restroom without the catheter for 9 months. And then after that, he had a surgery. The catheter was removed and the urethra was repaired. His bones were healing up. And again, he's not perfect. By no means is he 100%. He certainly couldn't do a job involving a lot of lifting. But I think that after a certain point in time, his condition improved to the point where he could have been a hand wrapper, let's say wrapping items for packaging or inspecting things, where he would be able to sit or stand is appropriate. It wouldn't involve a lot of lifting. It wouldn't involve a lot of production work. It wouldn't be real stressful, but it's something that he could do. And he's not actually tried to do anything. I think that he still kind of sees himself as being able to do physical work, and he's waiting until his condition improves to that point. But of course, Social Security is not about doing your past work or any specific type of work. It's can you do anything at all. So what I did in this case was I saw in my, at least when I talked to him in my mind, I felt like, well, you know, this is really probably more appropriate as a closed period case. And I talked about it with my client. I said, you know, I think that we may have a fallback position that if it doesn't seem like the judge is going to go for an ongoing period of disability, he might be willing to consider a closed period of disability. And my client understood that, was agreeable to that. I wrote a pre-hearing brief where I really laid out the evidence very clearly. I think one of the things we had going against us was that my client didn't have any money, didn't have any insurance, and after the initial trauma and finally the final surgery, he stopped going to the doctor. He couldn't afford to go, so he hasn't been to the doctor. His last visit was really less than a year after his accident, which again meant I didn't have any medical evidence other than his testimony, or really evidence at all other than his testimony that his disability was ongoing. So I wrote a brief. I didn't say in the brief that we're only asking for a closed period, but I kind of implied it by making sure that I identified that my client was in fact unable to do anything for certainly that 12-month period of time. And then during the hearing, it kind of went as I expected. I asked a lot of questions about the physical part of it, which is really more early on, and the closed head injury, which had still ongoing, but again, not disabling in and of itself. And then I talked about the urological issues and the catheter and so forth. And at the end of the hearing, the judge asked a couple questions, the vocational witness, one of which there were jobs that the VE found. The second one, there were no jobs. But I said, you know, let me firm this up. So I asked a question where I really, I think I even came out and talked about the fact that this hypothetical issue had lasted for a year following this accident, and it really involved the urological issue that my client needed a sterile restroom and so forth because of risk of infection, and then recovery from that. Bottom line is that I sort of sent the message to the judge that this is really about certainly 12 months. And after the hearing, after that testimony, the judge looked at my client and said, you know, I think I'm pretty comfortable that you've demonstrated that you certainly were not able to do any kind of work for at least 12 months after your accident. I haven't made a decision yet about whether that your disability has lasted longer than that or ongoing, but I want you to be certainly understand that I'm certainly going to find that you were disabled for at least a year. And perhaps Mr. Ginsberg has explained to you what a closed period is, and you know, I'll make my final decision on that, and you'll get my decision in a couple of months. So it kind of went the way I was hoping, and that was the judge picked up on what I was implying. He probably would have seen it anyway, but I certainly wanted to make sure it was very clear. And at the very least, I was able to get 12 months, you know, at least 12 months of SSI benefits, which again is not tons and tons of money, but it's certainly enough to put several $1,000s in my client's pocket, and it's probably the right decision in this case as well. So that's what a closed period is, and I would tell you that if your condition is one where you have improved or you think you could possibly work, that's a good fallback position, because not every case is going to be ongoing disability, and this is especially true if you're in your 30s or early 40s. Judges are reluctant to find ongoing disability when they feel like there's a possibility, a reasonable possibility that you could go back to do some sort of work. So that's my discussion about closed periods of disability. Obviously, for me, the important thing is to recognize who my judge was. Was he going to be open to that type of thing? Preparing my client ahead of time, and really not being greedy. And I think those are the lessons we can pull from this. I hope that's been helpful to you. And certainly, if you have any questions, let me know. So this is Jonathan Ginsberg, and that's my discussion about closed periods of disability.